But yeah, with that, we're going to be going through about 9 different things. We're going to talk just about IP in general. We're talking about working with a lawyer, trademark, copyright, patents, trade secrets, a key one for all of you, confidentiality agreements and employment agreements, a brief 1 second on government regulations, and then our guest speaker today. So as I said, yes, get your coffee, pull your eyes open, because this is a doozy. So with that, let's get into some IP, intellectual property. So for some of you, you might not have any idea what I'm talking about, but IP or intellectual property is basically what you're creating. It's a creation that comes from you and your mind. It can be an invention, it can be an idea, it can be a process, and it can be much more actually. And intellectual property is probably the most valuable asset that a business has. And it's one that a lot of us kind of overlook. So your IP can give you a competitive advantage because it actually creates a barrier or a buffer to entry that can prevent new companies from competing with the same products or services that you're offering in the same market. One of the biggest mistakes new entrepreneurs like myself make is not recognizing what your intellectual property actually is. In many situations, your business name, your logo, your website, brochures, your product, your service procedure or processes, and more can actually be legally protected from any of your competitors. Now, there are 3 types of kind of intellectual property. There's the legal, which is patents, trademarks, copyrights, and trade secrets. We have people, such as employees' knowledge and skills. And then we have relationships as an intellectual property, which are your customers, your suppliers, independent contractors, and consultants. And you should be planning to protect all of these proprietary assets. As an example, Coca-Cola, one of our oldest, most well-known brands, has protected its IP in a variety of ways, right? The artwork, on the can, on the bottle, has a copyright. The brand name and logo, well, they're trademarked. The formula of Coca-Cola is a trade secret. And the contour of the bottle was actually once patented as well. So protecting IP rights, it definitely takes time, and it certainly, depending on what you're applying for, can take a lot of money. Some are a lot easier to attain than others. Getting a patent, much tougher than just getting a simple copyright. But defending those rights is what maintains their value for your company. Like any business decision that you're gonna have to make, you gotta weigh the benefits of obtaining certain IP protections against the costs. So, sometimes at the beginning stage of your business, it's just a cost benefit analysis. I don't want to patent that because I can't afford to, so I'm gonna risk it, right? Okay, so let's get into working with an IP attorney. Attorney, lawyer, interchangeable vernacular. Attorney is the more common word in America. Lawyer is more common here. There are some other distinguishments, but you'll notice in the entrepreneurial manual, they use attorney. It's because it's an American manual. Now, a typical entrepreneur, relies on legal counsel for a ton of different subjects. And if you haven't, you should be considering, finding a business lawyer at the bare minimum, just a general business lawyer to kind of, start building a connection with. Now, since lawyers have come to specialize in many different areas of law, it's likely that you'll need to work with one or more lawyers in order to obtain legal representation for all your various activities. Now, IP issues can quickly become expensive and time-consuming, but an IP attorney helps to prevent those problems for you. The attorney spots the IP you might not be aware of in your business, and perhaps faster than you might do it, and then they devise a way to help you protect it. Even though it might feel painful to write that check to them, prevention is always cheaper than the cure. So it's important to find attorneys or agents who specialize in the type of IP law that's applicable to your industry and your business. And you're looking for someone who has considerable experience with working with entrepreneurs. Now, if your business lawyer is not current with IP laws, definitely consider asking him or her for a referral to a trusted IP attorney who can help you out. Today, we're going to meet one at 3. So in screening candidates, these are just some general questions for you guys if you're actually considering this, that you should ask yourself. First one is, can you communicate effectively with each other? That's a big one. If you've ever used a lawyer in the past, sometimes they might not be a great fit. And a lot of the times is that they can't explain things in terms that you actually understand. They'll just use a lot of vernacular that doesn't make any sense, or they're just going to be so high level, you're not really getting it. You want someone who can explain it on your terms. The other thing is to make sure they have the experience or expertise in your industry, and tell them to prove it. What have you done? How do I trust you? Okay. Fees and billing procedures, make sure they're adequately explained in your initial consultation meeting. You know, how you're going to be charged, what you're going to be charged for, when you're going to be charged. Is having a simple phone call, you know, an hour, or is that, you know, 5 minutes of their time? So those are things to always ask, because sometimes you get a bill that's a little unexpected. And that's another thing is, where are they accessible? How accessible do you need them to be? And that's going to depend, you know, on your various different businesses to know, you know, how accessible you need them. If you were starting at, you know, the next Facebook or something like that, well, you'd want your attorney on retainer, you know, always around and available at your beck and call. But for a lot of you, it's probably going to be more rare that you'll be checking in with them. Okay. And then the last thing is like asking them for that proof. What patents or technical items have they actually prepared and defended and prosecuted if you were to ever get into issues there? You'd want to know that they have experience with that on a technical level. Most importantly, make sure to find a lawyer who regularly works on issues similar to the issues that you might face in your business. Okay. So now we're going to jump away from this, and we're going to start talking about the 5 main types of IP, which is trademarks, copyrights, patents, trade secrets, and then confidential information. So the first one we're talking about is trademarks. Trademarks are awesome marketing tools. They help to distinguish goods and services of your company from competitors, and they add value to your company. By identifying goods with a trademark, you know, a consumer of your product or service associates the quality of the product with the mark. And that builds goodwill, and it builds brand loyalty with your customers. Commonly used trademark symbols, like you see here, a TM, an SM, and the letter R in the circle. You know, we see the R at McDonald's, we see SM at River City Bank, and TM at Starbucks. So the differences here we'll go over in just a second, but I just want to point out is that with registering with the R, the registered trademark, you can't use it unless your trademark is actually registered with CIPO. CIPO is, there's a link here, Canadian Intellectual Property Office. That's who you do all this patent and trademark registering with, is with CIPO. So the link's there if you want to learn more details. I've got that later on as well. So a trademark essentially is any word, it's a name, it's a symbol or device used to identify and distinguish the goods of one business from the goods manufactured or sold by others. So their words can be trademarked, sounds can be trademarked, colors can be trademarked, logos can be trademarked, fragrances and formulas can be trademarked as well. For example, got a John Deere tractor here. Well, this actual color green on tractors and lawn equipment and all the other things that John Deere has, they're the only ones that have this formula. It is trademarked, that distinguished green. There's, you know, car companies do this. There's a certain Mustang blue for them. I think the Mach 3, no other company can use it. Corvette has a red that nobody else can have as well. So there's so many things that can be trademarked and protected. And it's kind of on like this sliding scale that you see here. Generally speaking, you know, fanciful, arbitrary, and suggestive trademarks like we see here, they bear no or little relationship to the actual goods or services and are entitled to a relatively broad scope of protection. Now, when we get over to this side, we start getting into what are called descriptive marks. And these describe in some fashion, like sharp, they describe the goods and services and are entitled to protection only upon proof that the relevant consumers associate the name of the mark with the goods and services provided to the owner of the mark. And then on the far end of the spectrum, we have the generic trademark. These are simply words that mean the associated goods and are entitled to no trademark protection because they have become part of everyday language. So Band-Aid is the general term for all bandages, right? Aspirin is the general term for most over-the-counter pain relievers or even Tylenol, but aspirin was first. Thermos, right? So they become that generic name. A little hard to obtain that. And a name can become, so dominant that it takes on that generic meaning. So those are what we're meaning by the generic tag there. So tip of the day, it is a good idea to file for trademark protection on your company's name as soon as possible. New companies should also purchase all relevant domain names, don't learn from my mistake, to prevent other companies from buying them and competing with you. So if you don't own your domain name in a .ca, a .com, a whatever, .this, .that, and different versions of it, you should probably make that your homework today, okay? Cecilia, you have a question?
Yeah, if I already bought the domain names,
Yeah.
do I own them or can people take them somehow?
So if you lapse on renewing them, it depends on how long you bought it for. Typically it's 1 or 2 years. If you lapse on renewing it, your domain registrar will still hold it for you. But it depends on who you registered with. Some will release it back to public after a certain amount of time if you haven't re-registered, and then someone can negotiate to take it. So you just got to keep an alert set for when it's time for renewal. Usually your registrar will send you an email and say, hey, it's time to renew.
Yeah. Okay.
Yeah. Pretty simple.
But no one can take it once I've bought it, is my question. Okay.
No. Now that's not quite the same for your business name. That's a little different. So your name, technically, I don't know if you guys know this, but anyone can register the same business name as you. It doesn't legally protect them. It's stupid to do it. So when you register your business, sole proprietorship or a partnership, someone else can do that same registration with the same name. If you're not legally protected by a trademark or a copyright or something like that, that would be that next extension of them, of you defending yourself there. Okay. Brittany had her hand up first.
Yeah, so we have the .ca and the .com. Do you think that's enough, or we should also go into the European ones as well?
Well, your company's called Reed Supplies Canada. So I think under the current structure, I think you're okay with .ca and .com. I don't think you need to worry so much about registering in different companies unless you were looking to make direct distribution in those companies. So if you were looking to open up a warehouse and do more direct business in Europe, then you might want to consider it if you want to localize your website to those regions. So if you were going to make a website that was German and it's in German language, it's going to be for German musicians, then I would consider buying the domain suffix that is appropriate for that region in that country. Make sense?
Yeah, thanks.
Ebony?
Yeah, I wanted to know, so if I trademark my name, which is going to be in the domain, which is going to be everywhere, does that mean everyone who has prior to me trademarking it, do they all of a sudden have to give it to me because I trademarked the name?
That's a good question. That's a question for the lawyer later today. I don't know specifically. That's a bit beyond me.
Okay.
Yeah, I would save that one and write it down for later today.
Okay. But also, okay, I guess that's the same question in a different way. Okay, I'll ask the lawyer. Okay.
Yeah, I'm definitely not a lawyer here. Don't use me as your complete legal guidance, guys. That's for sure. Awesome. Brittany, you still have your hand up. You have another question?
No, just forgot to take it down. Sorry.
Oh, no worries. Okay, awesome. So now we can head into copyrights. So copyright's a little bit different, and copyright protection is available for an original work of authorship. We're going to watch a video on this because it's going to explain it better than I will. So it's available for an original work of authorship that is fixed in a tangible medium and can be perceived, reproduced, or otherwise communicated. Oh God, that sounds complicated, right? So we're talking about literary, musical, dramatic, choreographic, graphic, and architectural works can all be protected through copyrights. Even computer programs can also be copyrighted. Now, unlike patent protection, copyright protects expressive works from the moment they are created in a tangible medium of expression. So if you can prove you created it on this day and you've got that document to prove it, it's automatically protected from the moment you create it. there is no required registration or application process for your copyright to exist. So even so, it may be worthwhile though to register a copyright with CIPO, with the Canadian Intellectual Property Office, because it provides additional benefits. So registration is a prerequisite if you need to file a copyright infringement suit. So just because you have it and you can prove it, if you didn't register it, you can't defend it. So that it's kind of a weird catch-22 there. Now, registration before infringement also entitles the copyright owner to statutory damages and attorney fees. So that's the bonus as well. So if you have to go to defend it, you can actually get damages back. And then registration provides evidence of the ownership of the, of the work at the issue. So it's just more of a guarantee. So it is smart to register if you can, and if you've got the money to do it at this moment in time. So this video is just going to go in a little bit more detail around copyrighting in Canada. Okay. Did the song make it more exciting?
So much better.
I bet. I bet. Okay, so now we're going to talk a little bit about patents. Now, we might not have many of you here considering patents, but it's important to also know what can be patented. Cecilia, you have a question?
Yeah, I'm just kind of confused. It said you can use the symbol without actually registering it.
Yep.
Why? Like, why would you?
Well, because copyrights are basically created the moment you create something. So let's say you build your website. The moment you create that website, it is technically copyrighted by you. Now, you need to register it if you want it defensible. So if someone, it's kind of dumb, and I need a lawyer to explain it in much more detail to me. It is deterrent. Using the symbol is a deterrent. So when you see it, you go, oh, someone has created something unique here. I probably shouldn't steal it. Now, it doesn't keep people from doing that, but the registration therein helps that. Then you're actually, so if you find someone has duplicated your website and put their own name on it and maybe even stolen your images, you can then say, hey, no, I have the date I created it, and I've even registered it. So yeah, sorry about your luck here. But yeah, it's a little strange why, how all that
Oh
works.
no, he's gone again.
Yeah, I'm gone. I'm still here.
David, come back.
Hello? Can you guys see
There
me?
we go.
Now we can.
Yeah.
Oh,
Froze.
sorry. Yeah, my internet is a little wonky today. Sorry, guys. I'm not sure where I got cut, if I got cut off there, Cecilia.
No, that answers my question.
Okay.
Yeah.
Cool. Awesome. Okay, so patents, well, typically, we think of patents, we think of inventions, right? And usually they help to ensure that inventors can be the ones to actually profit from their inventions. Patents help ensure that our creations can be that our creators can be the ones to actually keep what they've created to themselves. So they're granted by the government to whoever invents or discovers, this is key, a new or useful process, a machine, a manufacturing process, a composition of some type, or any new or useful improvement of any of those. So the company I'm involved with right now, we have a utility patent, and it's for a process that we've created. Now, patents are legally viewed as intangible personal property, which means that they can be bought, they can be sold, they can be traded, and they can actually be licensed out just as any other piece of personal property we might own. Now, through a patent, the government gives you, the creator, the right to stop others from making, using, or selling your invention from the day the patent is granted to a maximum of 20 years in Canada. I think in the United States, it's 50. Or it might be 70. After that day, after that day expires, it becomes in the public domain, okay? So here we've got another video. Tell you more about patents. Okay. Loving this music a lot here. All right, now we have an actual lawyer who's going to tell us a little bit more about patents in detail. Okay.
So what are patents? Well, a patent covers an invention. And a patent structurally is very simple. It has a write-up, a description of the invention, and at the end it has one or more claims, each claim setting forth what you think is your invention. And if the patent office agrees, that's the protection that you get from your patent. So think about this. Ask yourself first, is it potentially patentable? Work with your patent lawyer on this. They can do a preliminary search and give you some guidance as to whether or not this particular point may or may not be patentable. If it is patentable, ask yourself the question, is it technologically feasible? You know, the idea, wouldn't it be cool if we had a time machine? That's not an invention. It's a great idea, but it's not an invention. So ask yourself, are we there yet? Are we at the point where we have a technologically feasible invention? If the engineering side of the house thinks they can get there, and if the patent folk are saying, yeah, it looks like we can probably get patent protection for this, then ask this third question, is it commercially interesting? Because just the fact that it's a cool idea doesn't make it commercially interesting. But if it's patentable, and if it is technologically feasible, or we think we can get there, and on the commercial side of the house, they think it's a product point worth pursuing. That triple overlap, that's where you put your patenting dollars. So what is patentable? Technological features, products themselves, certain processes can be patentable, but they have to meet the statutory requirements of novelty, non-obviousness, and usefulness. What do we mean? Novelty means it wasn't available to the public previously. It wasn't in an earlier patent, it wasn't in a publication, no one was using it in the marketplace earlier. If the idea is already out there in the public, it's not patentable anymore. So you're going to have to watch confidentiality very strictly in the early days until you get your patent application filed. Even if it's novel in that sense, it still has to be non-obvious. And what we mean by that is that those who practice in this area, those that are skilled in the art, as they say, wouldn't find your idea obvious from the prior art that went before, from the prior patents, from the prior publications. Whether something is obvious or not is a tough, tough question that lawyers fight about all the time. Finally, it has to be useful. Well, you wouldn't be bothering if it weren't useful. Of course it's useful. Those are the three requirements. It's got to be novel, it's got to be non-obvious, and it has to be useful. One important point to keep in mind, if you do decide to file a patent application, you're going to have to give all of the prior art that you know about, that's all the earlier patents and publications that you know about, to your patent lawyer to submit them to the patent office. I know it seems like you're shooting yourself in the foot, but it's terribly important. There is an obligation on patent applicants to bring to the examiner all the prior art they know about. And in the long run, it will make your patent stronger because the claims will be crafted to avoid that prior art and be patentable over that prior art. If your patent attorney and the examiner don't know about that prior art, they might mistakenly issue broad claims that cover the prior art. Any claim that covers the prior art's invalid. So this is a lose-lose proposition. Bring the prior art to the patent office, get a strong patent. So a lot of companies use invention disclosure forms. These are forms that are available on the internet. You could probably find some. We've got some of the materials attached to this. It simply provides information that the patent lawyer can work with to begin the conversation to determine what is the invention and what do we want to try to protect here. It doesn't have to be the great American novel, usually the names of the people involved in that particular work, some brief description of what they think the invention is, what they think the new part is, and maybe a few other bits of information such as how they think it's going to be applied in the business, maybe what they know of the prior art. Remember, things that have gone before, what did they start with? What did they work from? They should record robustly, and it should be in an organized fashion, dated and all the rest of it. So you've got records. Now you're in a position to review those records and make sensible decisions as to which of these technology assets are we going to try to protect with which forms of intellectual property, patent, trade secret, copyright, whatever it might be. That gives you an opportunity in a sensible and sound and efficient and cost-efficient way to build your IP arsenal. Your IP arsenal, remember, is part of your IP strategy that supports your business plan. It gives you competitive advantages in the marketplace, and that's what your IP ought to be doing for you.
Awesome. Now we'll talk a little bit about trade secrets. Now, trade secrets is basically any business or technical info that gets value from not being known in the public domain. And the owner takes a reasonable precaution to protect and keep this information confidential, okay? Trade secrets can be very valuable when you've developed something new, a new technology, a new process, a new pattern. Can be something original. It can be, creating the perfect recipe or putting together, a bunch of customer data. Evie, I'm looking at you. However, it may not be the best choice of IP protection if your competitors can easily reconstruct your creation. One of the most famous trade secrets, we talked about Coke earlier, is the Coca-Cola formula. It's still a well-guarded secret, and it has been for over 100 years. The business value of the formula is why the company goes to extreme lengths to keep it confidential. So there are types of information that can be protected as a trade secret. And these are what we see here, formulas, patterns, programs, computer programs, devices, a compilation of information. It can be a method you're using, it can be a technique or a certain process. Now, there is no formal application or registration process for trade secrets in Canada. So you should consider different ways to keep your valuable business information secret. And this includes, having employees, vendors, partners, and others with knowledgeable information about your business. You should have them sign a non-disclosure or confidentiality agreement when they're exposed to that information. Confidentiality clauses should be included in any employment agreements that you create in the future. Making sure you're using encryption and password protection properly on anything related to your business. Don't use the same password for everything and save it with Google. Bad idea. You should also, if you have a physical place of business, making sure you're actually securing your facility with proper lock and key and maybe cameras. And then limiting the number of individuals that actually have access to the information. If there's something you're trying to protect, you might not want to trust everybody, okay? And then once you're at the point where you have employees, making sure you conduct exit interviews for those who are leaving the company to remind them of their obligation to keep confidential information about your company a trade secret, okay? Remember, once trade secrets are made public, your businesses, they lose value. And those remedies that you might need to try to deploy to actually fix it, might not work if whatever the trade secret was isn't protected. Okay, Ebony, yes?
So it sounds like trade secrets really aren't anything, because all you're saying is don't tell our processes, but there's nothing to protect it.
Right. Essentially, it's not a legal anything. It is essentially a construct, right? A trade secret, if Coca-Cola has their formula, it's on them to protect it. We call attention to it because now you should be thinking, well, do I have any trade secrets that I don't even realize I should be protecting, right? That's why we at least call attention to it. And you're right. Yeah, there is no formal way to protect it in our formal registration process with it.
So does Coca-Cola have their recipe patent? Like have a patent for it?
Sorry. It's a little tricky. So yes, they would have a patent on the formula, but it is also a trade secret. A patent can be a trade secret. They are not mutually exclusive in that way. But sometimes a trade secret might not be something you can copyright or patent.
Okay.
In that way. I know it's a little confusing. There is overlap here.
So like a trade secret would be like the way that like we produce and organize our content and dispatch it quickly, or like if that's like our thing is getting stuff out quickly, like how we do that would be like a trade secret, I guess. Right. So anybody who gets hired on, you have to trust enough to not leak it, I guess. And like, what are you going to do? Nothing, because you don't even know if they leaked it. That's
right. So that's why you got to really, take stock of like what might be something proprietary in that regard with your company. What are the things you should be protecting? Yeah, if it's the way you produce content, it could be the way you edit, settings on your camera. It could be, filters that you've decided to use, or the way you do editing, right? So there's lots of things you should take stock in and think about this as you're going through what you do in your business, especially when you eventually get to the point where you're going to bring outsiders in.
Yeah, we kind of talked about that, about like maybe possibly taking in students, because like we have a lot of data, like our information to like give out to students with regards to editing and stuff. And then we discussed like, well, but how do we do that safely?
Yeah, having them, having an employment.
Word for it.
Yeah, and we're going to talk about that in a couple seconds. We'll go over employment agreements and things like that, and what to include in there to protect yourself. Working at Fanshawe, I had to sign a confidentiality agreement. Technically I have access to all sorts of stuff about all of you if I wanted it, right? And, I could do all sorts of things with that information. So we have to sign that stuff, and there's trust there. And back in the day, it's going to really date me, but I worked at Blockbuster for a long time when I was younger. And believe it or not, Blockbuster made us sign like a 15-page like NDA, because we got movies way before release dates. We were able to review them, look at them, and things like that. And they were quite protective over the copyright of that material, and what we could and could not do with it. And it even went so far as like if I was never allowed to speak to media, and there was a lot of clauses in there. It's pretty interesting. So yes, Ebony.
So does this only work in Canada? Like all of this legal stuff that we do, if we do it in Canada, can it still be applicable if someone in a different country infringes on that?
Yeah.
Or you,
no, yeah. So some of these things like patents have to be registered in each individual country. Copyright might be a little bit different. I'm not quite sure. That's a question for your lawyer to talk a little bit more specifically, but I know for a fact that yeah, patents are country by country. I'm not sure. I think same with registering a copyright, it has to be registered country by country. So this is where it can start to get expensive, right? If you're looking to register around the world and things of that nature. But yeah, usually they have a governing office. You have to register with each one, and there's a process for all of that.
And with NDAs and employment agreements, are those also you have to do it within the country, or can I just?
No, that's different. So an NDA is a contract that, that you can just create yourself. You should have a lawyer review it to make sure the clauses are sound. But an NDA would be kind of universal. Anyone who's involved in your organization can sign that, and that crosses borders. Because you're not registering an asset in that situation. That's more about protecting information. So is a little bit different. Now there is a guide I've got in here. I've also put the link on FOL under the additional resources tab. That goes to the CIPO page, and it has a full guide on all of this. And in there, Evity, is how to register in other countries as well and what to look for. There's also information on fees associated as well. Like if you're wanting to do some of this yourself without a lawyer, you can see what it costs and what the process is. Yeah, we're gonna watch this quick video and on trade secrets. Sorry, guys. Sorry, I just want to point out, like, I think it's really funny. He's just standing in a library for some strange reason.
If you decide you don't want to pursue a patent, either it's too expensive at this point or it's not the right kind of technology for a patent protection, you might decide to keep it as a trade secret. A trade secret really can be any commercially important information. How to produce a product, some little trick in the processing. It could be a customer list. Trade secret could be business plans. It can be a lot of things, and it's an asset of your company that you need to protect. Now, when we say you have to protect your trade secrets, we really mean it. The courts will not be sympathetic to you if you accuse someone of stealing your trade secrets if you did nothing to protect it, or if you didn't do enough to protect it. You have to have a policy in place and procedures in place to protect your trade secrets. Now, have in mind, there's no government grant, there's no registration. You don't file a secret paper with the government to register your trade secrets. You simply know them, and you hope that other people don't. If other people come across those trade secrets on their own, if they invent the same process, if they come up with the same customer list, they're free to use it. There's nothing you can do about that. You can stop them if they misappropriate your trade secret by talking to your employees and getting them to divulge secrets they shouldn't be divulging. That's wrong. You can stop them. But if they come up with the ideas on their own, I'm afraid they're free to use those ideas. If somebody leaves your company and begins to misappropriate your trade secrets, you're going to want to act on that. So, what do you need? You need records that show you had that concept in place, in mind, recognized that it was a trade secret, that it was an asset of the company, and took steps to protect it. Now, taking steps to protect it, that's probably going to be a general description of what the company does to protect its trade secrets. Locking doors and having robust IT protections and keeping papers off desks when visitors are in the area. All of that. A judge is actually going to want to know that you took steps, affirmative, real, concrete steps to protect your trade secrets. If you did, then the judge will help you protect them. If you treated your trade secrets glibly and didn't really bother to protect them, the judge is going to be unsympathetic. Hopefully you've been diligent in your employee intake and in your employment policies. All of your employees know not to use trade secrets learned from another employer before they came to you. Good, that's all great. Nevertheless, the day may come when you're accused of having misappropriated someone's trade secrets. If that happens, dig in. Take a look, do a study, see whether or not there really is a problem. There very well may not be. It's easy to make allegations, it's harder to prove them. But you don't want to be on the wrong side of an actual trade secret finding. So do your homework. When the allegation is made, take it seriously. You might very well be fine. If you're not fine, remedial action. Do what you need to do to get the trade secrets out of your product. Or maybe take a license. It's possible that the trade secret owner would be happy to have the revenue if you are willing to pay a license fee to use that trade secret. So with everything else you have going on, paying attention to your intellectual property strategy is going to be crucial to your business success.
Okay, so let's jump over to confidentiality agreements. And obviously you might need to share confidential information at some point, in order to advance, your business and grow your business, or it could be for some type of financial transaction. There's lots of different reasons why we might share this information. It could be with our vendors, it could be with our partners, it could be for the potential buyer in the future of our business, it can be with a business advisor, it could be with a colleague here in this program. But we have to make sure that you safeguard that information with some type of agreement. It's usually called a confidentiality agreement, or what we call an NDA, or a non-disclosure agreement. Now, confidentiality agreements can be what we call unilateral, meaning that only one party takes on the confidentiality obligations, or they can also be mutual or bilateral, meaning both parties take on the confidentiality obligations. It depends on the scenario. If you're sharing one-sided information with a vendor, well, they should be signing a unilateral confidentiality agreement. If you're sharing it two ways, then it should be a mutual or bilateral agreement. Now, here are some typical situations where a confidentiality agreement is used. So it could be when you're presenting a business idea. I've signed many NDAs working for Leap Junction, where people are coming with new ideas and they're hoping it won't be shared. Now, automatically, we don't share those ideas, but I've had people do that. It could be you've got a new invention, but anytime where you think you have something that's worth protecting, it might just be a good idea to have it. Now, take it with a grain of salt. Some people may get offended by it, but remember, it's your business, it's your idea. If you feel like it's worth protecting, they shouldn't be upset by that, okay? It could be when you're sharing, as I said, sharing any financial or any marketing information as well. That is key, or just any other general information, but that financial and marketing, internal information, and it's relating to your metrics, your analytics, or, that internal financial data is very important to make sure that you're not just being frivolous with it and giving it away, because there's a lot that can be gleaned from that. If it's a new product or a new technology that you're showing off, that's a good time for an NDA. And, if somebody, if your company or someone in your company is going to be providing, if somebody that you're working with is going to be providing you with services and is going to access that sensitive information. So this could be you hire on an accountant, you hire on a lawyer, you hire on an IT, someone to come in and fix your IT system. You may have to have them sign NDAs as well. Okay, and I've also included a link to Deal Prep, which is on FOL for you. Deal Prep is a service that you guys all have access to for free if you register. It's through us. You just there's instructions there. There's a link. It'll take you to a registration page, and then there's instructions in the description. You just list Leap Junction-Fanshawe College as the organization you're affiliated with. You'll have access to over 100 various contracts that are templatized, and it has a contract wizard there that you can actually just start filling in the information. It builds the whole contract for you. You also, when you're on the platform, can access a lawyer at any time through the chat, and it's all there for free for you guys right now. Okay. Employment agreements, which we mentioned earlier. So this is about, protection of your business from within. So obviously, some of you don't have employees right now. Some of you might not ever, but some of you might be planning in the future. And eventually these individuals might have access to some type of confidential information about your business. So you got to make sure you take the steps to ensure that they don't intentionally or accidentally reveal your secrets to competitors. So we have to create written agreements, and that's the first step in protecting your IP. So you probably won't have every employee sign an employment agreement. Most will simply sign an offer letter or, an employee handbook that you have to sign. But legal documents demonstrate that you're serious about protecting your IP and that you are willing to prosecute those who betray your trust. Make sure you consult with your lawyer about creating these appropriate legal employment documents for your industry. So you might be able to, find a template, but just because you found one on the internet or through deal prep or something else, doesn't mean you shouldn't have a lawyer review it to make sure it's hitting all the right points for your specific situation. Additionally, your employment agreement should include a statement that all employees, all of their work and all intellectual property rights in that work are owned by the company and are not to be used by them personally outside work or by future employers. That is an important clause to think about, especially if you're in a business where, I'm thinking of you guys, Tracy, you bring on a second shooter and they figure out your whole system and how you work, and they take your customer list and kind of just start undercutting you, right? So you should have something like an agreement like this that has a statement or a clause that has like a non-compete, for example, or something like that, that doesn't allow them to take that information.
The other thing is, like, if they shoot for me, technically those photos are theirs. So upon signing it, it would become ours because we're paying them for their work.
That's right.
So we can sell it because technically I can't sell it without their permission. So.
Right. Yeah. So they would have to agree to that, right? Under those terms. So there are a few agreements to be familiar with. The first one we've already talked about is kind of the general NDA. So you should, as I said, require that all employees sign one. Best time to obtain this agreement and this signing is at the hiring and during the hiring phase. So as part of the NDA, the employee should agree to not improperly use or disclose information about you, your business, and your clients, okay? When they leave, make sure that they return all of your company's documents containing confidential information and make sure you remove their access to such. This could be customer lists, could be manuals, anything you can kind of think of there. At that time, the employee should also be reminded not to violate the confidentiality obligations that were signed in that agreement. So make sure to call back their memory to that. You should also make sure that your agreements with any independent contractors have a provision not to disclose or misuse any confidential information, okay? And you should also include a provision stating that the company owns all intellectual property rights in the work produced with that contractor. So that's probably more what Tracy's referring to there. Now, the non-compete, that's our second kind of main type of agreement, and this limits a former employee's rights to work for someone who is a direct competitor of your business. Now, you have to be selective about who is going to sign a non-compete agreement. Not all employees need to sign this. Only those employees who truly possess inside information should be asked to sign them. And non-compete agreements must generally be limited to protect a legitimate business interest. And they also have to be limited both in time and geographic scope in order to be enforced in court. Now, non-competes are a little tough to actually enforce if they are not documented well, both with the time restriction and the geographic restriction. So make sure that that's documented. The last one is what we call a non-solicit agreement. And this basically prohibits employees for a certain time period following employment with you from soliciting other employees in your business to leave the company and work elsewhere. So non-solicit agreements are, important in businesses where someone might, come to learn, leave to start their own shop, and try to solicit others to come work for them because they're going to do it better. That's why we have non-solicitation agreements. So I think, I don't know if you guys ever seen Jerry Maguire, for example, back in the day. That's kind of what he tries to do, pull people with him, all those agents. Okay, so just one more video here on employee policies from our awesome friend here.
An important part of your intellectual property strategy is implementing best practices in the area of employee policies and procedures. So what do we mean by this? Well, really think of it in three major aspects: employee intake, employment agreements, and employee exit interviews. New employee intake. It's an exciting time. You're bringing new people on, but you have to think about baggage. You have to think about contamination. You're hiring someone because you have faith that they're going to do a good job for you. Probably they have some experience in the area. What you need to be sure is that they're not bringing with them, for example, trade secrets of a former employer, because their former employer is probably going to notice and they're going to do something about it. So there's that due diligence aspect when you bring somebody in. Make sure you're not contaminating yourself. Make sure you're not buying a problem. Another aspect important to employee intake is policies that you have in place from the beginning. And most important is the policy that you will not take advantage of trade secrets brought to your company in the minds of the employees that you hire. You want in place something that you can show people, a policy that says we don't want them to disclose those trade secrets, we won't use them. Do intake interviews, formal intake interviews. It may seem a little tedious, but call this out. There are probably a number of things you want to talk to a new employee about, of course. One of them should be this policy. Don't bring with you trade secrets or other materials from a former employer. Just leave them behind. We have confidence that you're going to do a good job because you're a smart person and you have experience in the field. We don't want secret information from another employer. Your company's employment agreement for employees will probably be prepared by a general counsel. Make sure that it has provisions in it that adequately protect on the IP side. There are several provisions that it really should have. There might be some special to your business, but at least it should have these. First, it should have a confidentiality obligation. It stands to reason that employees shouldn't really be telling the trade secrets of their employer, but put it into the agreement anyway. Have an obligation out loud that the employee, even after they leave employment, will not disclose the trade secrets of the company. A confidentiality provision in an agreement is an enforceable aspect of the contract, and we've had cases where we've had to use them. We had a client who lost several employees, several key employees, to a competitor. And suddenly the competitor knew our bidding practices and our bidding points, price points, and seemingly knew our technology because they came out with a product awfully close to our clients. So unfortunately, we had to go to the courts for justice, and we were successful. And having the confidentiality and the non-compete provisions in the contract were very, very useful. Also, it should have a non-competition provision. It has to be reasonable, not too long in duration of time, and not too broad in terms of scope. But it should be reasonable, and it can extend for some time after they leave employment. That's not too much to ask. You can't enforce that in some jurisdictions. California's notorious, but most jurisdictions will enforce a non-competition provision. Also, obviously, you should have an agreement provision that says that inventions made by the employee are owned by the company. They're assigned automatically at the time they're made. And it should be clear that we're talking about inventions made 9 to 5, of course, but who works 9 to 5 anymore? Any time during their employment, even if they're watching a sunset, they have a bright idea, it relates to their work for the company, that invention is owned by the company. Provision should say that in the employment agreement. Also, an obligation to disclose. It may not be self-evident, but the employment agreement should obligate the employee to disclose inventions that they make to the employer promptly. Finally, there should be a provision requiring the employee to assist in obtaining IP protection. I'm not talking about heavy lifting here. Signing documents for the US Patent Office or other agencies, perhaps assisting in understanding some of the invention as it's being prepared in a patent application, that sort of thing. For some little period after they leave employment, it's not unfair to ask. It's really a fairly common provision in a lot of agreements. And of course, require immediate signature of an employment agreement. You know, especially in the very early days of a business, sometimes this gets left for later. Don't leave it for later. Have the employment agreement signed right away. So it does sometimes happen, employees decide to leave. You need to have policies in place and procedures in place that make sure that you're protected when an employee does leave who is important to your business. First, do an exit interview. Exit interview isn't complicated. They wouldn't leave without saying goodbye. Talk to them a little bit. Remind them about the obligations they have even after they leave under their employment agreement. Just because they're leaving, the employment agreement doesn't end. It goes on. Confidentiality, obligation to assign, obligation to assist. Remind them of these things. It'll make it easier if you ever need to call on them to fulfill some of those obligations. In some cases, you may suspect that an employee is leaving to form a competing company. That's a problem. Or maybe going to join an already existing competitor. That can be a problem. You might consider monitoring that new company for a while just to make sure that they're not using your trade secrets, your technology. It wouldn't be the first time that it happened, and it wouldn't be the first time that an employer had to go to court to stop the practice. So with careful planning and implementation, you can hire employees that will contribute hugely to your business while creating and protecting intellectual property that will be essential to your company.
Okay, Abby, you had a question?
Yes, I originally thought non-solicitation agreements were not soliciting the customers of that business. So is that possible too, that they can also be not soliciting fellow employees as well as customers?
Yeah, so a non-solicitation, I think, extends also to not taking that information. So like you're talking about, if I had a customer list,
Yeah.
and I left and I'm taking, yeah, that would also be included in there as well.
Okay, thank you.
You're welcome. Ebony?
Yeah, I just had a comment. I know you said this was supposed to be boring, but I'm like, I'm just loving this because I had someone that was working for me, and I think I shared it with you, like, but in Africa, and we're working on things, and at one point they started taking it personally, keeping information from me, you know, and all this kind of stuff. And I'm like, how do I, like, at one point they had an illusion that we were partners or something because I had never got them to sign anything. They started to get attached to the work they were doing for me. And so this solves so much, and this gives me so much more confidence in being able to not have like trust issues with partnering with people. So this is awesome.
I'm happy that, you know, in that case, Ebony, you know, and this goes to all of you who are maybe currently working with other people right now, to bring something to light. Now, obviously the husband-wife scenarios here, that's a little different, but you may want to think about creating what's called either a statement of work or just an initial agreement between you. You know, so if you're going to be working with somebody, you know, before your business is registered and created, there is documentation that you can use to protect yourself in those scenarios where it just kind of clearly lays out, you know, the relationship you have at the moment before the company has a formal structure, and, you know, what the intent afterwards is when the business is formed. So if you were working with this individual, you know, over here, and you're both working together, it would clearly state, you know, that relationship for both parties and what the expectations are. So there would not be any confusion. That happens a lot before our companies are, you know, incorporated or registered. And, you know, and a lot of the time we avoid these conversations, especially in partnerships, because they're tricky and they're sticky and they can lead to upset feelings and things like that. But honestly, the legal part of your business should be one of the first things you deal with. And if there's others involved in bringing this to, you know, market with you, make sure they all understand what they are entitled to, what they're not, and what the relationship is all about. Okay. Yeah, Tracy, definitely contracts just with your clients as well. And that's not something we cover here. You know, service agreements, they're pretty standard, but all of you who work, you know, are producing a work that will take time, and it requires an agreement with a client, you should all have contracts. If you don't have one, I know Cecilia and I talked about this yesterday, you need to get that in order. Deal Prep has service agreements on there. There's lots of other templates as well. You can ask the lawyer about it today, but man, oh man, do you need to get that, especially when it comes to video work, editing, all that stuff. I've had a lot of people come through here doing similar things and just get dragged over the coals because they didn't have clear contracts that stated what the work was and what it wasn't, and how much and how long and how many revisions and how many of this, to the point where they're not even making money from that initial contract. And it's usually a hard lesson learned that you may, you know, you learn it once and then you don't make that mistake again.
Another thing I'd like for everybody to know about is contracts for anybody in photos on websites for their products. They all need contracts because they could come back and like whatever, like if you end up starting to make like a lot of money, they can come back and be like, I didn't approve you to put that online. for the world to see, and now you're gonna have to pay that. Like they could sue you, just so you know. But if you get a professional photographer and videographer, then they're on the line for that. So
Yeah.
just so
Now, obviously, you can always, there is stock photography, but make sure you're checking the Creative Commons license on that stuff to make sure that, that it is eligible to be used on your type of site. But I would go with Tracy and say, yeah, you want custom imagery, custom artwork for your website and for that content, once you can afford it, for sure. Cecilia?
Okay, this might be a question for the lawyer, but I'm thinking about partnering with another organization to launch this collection for the summer. But is there anything like obvious I need them to sign? Or is that just, is it kind of just like case by case, or?
Yeah, you would definitely want to have a contract depending on what they're having access to, what you guys are doing. Like, are you paying them?
I don't know yet. It's literally like a thought I had this week. I haven't even like reached out to them yet.
Depends on where you sit in that relationship with them, right? So if they're providing you a service, most likely they'll be sending you an invoice and you'll have a contract. You know, you'll have to sign on to that states what they're providing to you, but you can also hit them with an NDA or whatever else that you want them to sign to protect yourself too. Depends. Now, if they're coming on as a full partner in some way, shape, or form, then you might want to have you know, clear establishment of that relationship through either what's called a statement of work or another type of various contracts that are out there. Now, that's getting a little bit beyond my knowledge base. I might have to know more about the relationship, but that's definitely something you would talk to a lawyer about and explain that scenario.
Okay.
Cool.
Thanks.
Okay, so quick summary here. So, but what we just went through. So sometimes, you know, your most valuable asset is this IP, and that's not readily apparent, right? Your customer list, a key employee, your knowledge, a special recipe. You know, we often think of like, you know, certain assets in our business or the business as a whole as the most important thing, but sometimes it's actually just the IP we create. And these all have value because a lot of them can be sold or licensed afterwards. You know, just because you're working in the business today doesn't mean that's where you're going to be 10 years from now. And all of this stuff has value if it's registered and protected. Intellectual property, as we mentioned before, it can give you an edge with the competition because it protects you, right? It protects you and it shows that you're serious, which, you know, makes your competition take notice. It also is more likely to gain trust, you know, with your customers. They say, oh, this business is serious. They protected themselves. So there is a lot of, my God, perception that comes along with that, right? From the consumer's perspective. Now, getting assistance from lawyers to obtain this protection is something you should definitely consider. Remember, we said prevention cheaper than the cure. And you should certainly explain your plan to protect your assets in your business plan. So what we went over today is actually part of the readings from last week. And this goes into your product and service plan. There is a clause in there that talks about IP protection. So this is where this information would come in. So if you are going to use any copyrights, trademarks, any of this, you would describe all of that here in a little bit of detail. And there's definitely a lot more information available on the CIPO website for all of this in great detail. Okay, so I put the list here. It's just on this link and then it's on FOL as well. So you can check out that for more information. Cool. So we're gonna do a little quick exercise here. Anybody know this restaurant under the volcano? Yeah, pretty good Mexican food, I think at least. So this is going to give you an opportunity to practice analyzing proprietary aspects of your business and another business and then apply it to your own concept. So I want you to think about your favorite non-franchise but theme restaurant. So I'm thinking about Under the Volcano. You can think about whatever you want locally. It could be, oh no, they're franchise now. Never mind. I was thinking of V-Spot. They're pretty great. But whatever place you love that has unique menu, decor, and recipes. So I want you to take 5 minutes and we're going to brainstorm in groups of 3 and just make a list of all the potential intellectual property that that restaurant might have and in which category it would be properly classified. So this is on page 165 in your manual. And there's just a list there. It's just a quick chart. So I want you to spend 5 minutes brainstorming with your partners. You can also, on page 146 to 153, if you need help to go back and say, okay, what is IP again? You don't remember from this presentation. It's in the manual there as well. And I'm going to, for those of you who don't have it, I'm going to throw it back in here for you. Okay. Okay. And yeah, so at the 5 minute mark, I'll message you guys in the breakout room. So you'll have a little bit of brainstorming happening. And then you're just going to switch to working on steps 2, 3, and 4, which is about thinking about your own IP. Okay. So step 2 is just you're going to now think about yourself and go, what IP aspects, could I maybe protect? Maybe it's my logo. Maybe it's a pattern I created if I'm Cecilia. Step 3 is just, okay, how can I protect that? Am I going to apply for a patent, copyright, a trade secret? And then step 4 is just listing out a couple questions that you might want to ask the lawyer who's coming in about 15 minutes. Okay, any questions about that before we move into our breakout rooms? It's all explained there for you on page 165, if it's not clear. No, okay, so let me just make these rooms for everybody. One second. Sorry, guys. There we go. Okay. All right. If there's no questions, I'll send you away and feel free to pop back in if there's anything you need help with. Alrighty. Good luck. Okay, great. Well, I hope you had some good discussions. I hope you helped Under the Volcano out by listing off what might be the things worth protecting with their business. And I hope you got some things listed out for yourselves. But as you can see here, we have a special guest hanging out with us. If you can see him on the screen, his name is Jaime Holroyd, and he has graciously given us the next half hour of his time to speak with all of you and discuss, legal protections for your business. So thank you for joining us, Jaime. Really appreciate it. Everybody give Jaime a nice Loop Junction wave. Excellent.
My pleasure. I look a little different from my firm photo these days. I got the COVID beard going here.
That's why I've got my hat on and the beard growing too. So Jaime is an associate lawyer with Siskins Law Firm in the Intellectual Property Group. And he focuses on drafting and prosecuting patent and industrial design applications, assisting clients in managing their intellectual property portfolios, and representing his clients in intellectual property infringement actions. Jaime is a registered Canadian patent agent and a registered United States patent agent, and he is here for the next half hour or so to chat with us, as I said, about protecting your IP and hopefully answer just some general questions that you might have. So with that, Jaime, the floor is yours, and take it away, and thank you for joining us.
All right, well, thanks, David. So as David mentioned, my practice, I've been practicing for about 9 years, and it's been focused on intellectual property since I started. The focus of sort of day-to-day what I do has shifted a little bit. When I first started, it was mostly in litigation and opinion work. So I was kind of, fighting in court stuff most of the time. or assisting in it anyways. When you're more junior, you don't typically get up there and make the arguments. But so I still do litigation these days. So I spend some time in federal court and federal court of appeal, but most of what I do these days is what we call agency work, which is the work of securing, applying for and registering intellectual property rights for people. And then also transactional work, so licensing and selling or buying intellectual property. So that's more what I do, and I frankly like it better because there's a win for people in applying and registering, whereas kind of everybody loses if you're in litigation. So, you know, it's a happier, more fulfilling practice for me. But if my clients need to sue somebody or get sued, then I can help them out too. So anyways, enough about me. I'm going to skip a little bit of the general stuff about intellectual property because I understand you guys have kind of covered that already. So I'm going to go right into sort of the main three types of intellectual property: patents, trademarks, and copyright. And I'll talk a little bit about a couple others if we have time, but those are the main ones that most people are kind of primarily interested in. And I'll talk about what they cover, what kind of rights those entail, and how you protect them, how you secure those rights. So basically, intellectual property rights are exclusionary rights. They let you stop other people from doing something that you have the exclusive right to do. So it's similar to the way real property rights let you prevent people from trespassing. Intellectual property rights let you stop people from infringing. So the concept is kind of similar, but what that exactly looks like is different and depends on the kind of intellectual property you're talking about. So for patents, which is the first one I'll talk about, the exclusive right you get in patents covers inventions. And so inventions are kind of new and useful machines, products, or processes. And you get the exclusive right to make, use, and sell the invention, whatever that looks like. And so anyone else who does any of those things would be infringing your patent. And patents are an exclusive right that requires registration. So there's no patent rights without applying for and registering the patent. And that's a little bit of a unique feature of patent protection compared to some other intellectual property rights. So there's a timing aspect to patents that's critical. You have to apply before your invention is made available to the public. And that catches some people out because naturally, starting up, you're excited to get the product out there, put it on your website, start marketing yourself. But you can actually ruin the patentability of your invention if you publish it before filing your application. Some countries like Canada and the US have a 1-year grace period. So you're sort of able to have some leeway, but most jurisdictions don't. Notably, Europe does not. And so you can inadvertently damage your prospects of getting a patent if you're not aware of that publication bar. So that's an important thing to keep in mind with patents. That's a little bit unique. So basically what a patent is, it's a 20-year monopoly on your invention. And it's a term limited monopoly. And the idea is that essentially there's a bargain that's struck in the Patent Act between the public giving a monopoly to an inventor and an inventor disclosing their invention to the public. It's called the patent bargain. That's what we sort of talk about because the general rule is free competition and monopolies are bad. But with patents, we're giving people monopolies in exchange for telling the world about their great idea. So the idea is that after 20 years, anyone is free to use your invention, but for that 20 years, you're the only one that gets to use it. And that's a way of driving investment in research and development. So if there's a promise of exclusivity, investors and big companies are more willing to put money into those ideas and the effort to generate those ideas. That's the theory anyways. It works out pretty well most of the time. So anyways, that's what a patent is, but how do you get a patent? What does that process look like? This is a big part of what I do on a day-to-day basis. What you do is you have to file a patent application with the different patent offices around the world, because most intellectual property rights are protected separately in each jurisdiction. So a Canadian patent won't protect you in the United States and vice versa. So what is a patent application? What does that kind of look like? What's the process? Typically, the first step is something called a patent search. And what we're doing there is we're looking for other similar inventions that people have tried to patent before or that are already out there. Because the main criteria for patentability is that the invention is new. We call that novelty. Because if it's out there already, the idea is that the patent bargain doesn't want to give you a monopoly for something that already exists. You've got to be bringing a new and useful invention to the patent office in order to get your patent granted. So that's what we're looking for with the patent search is the same thing already out there, and is it likely to meet that standard of novelty when that application gets examined by the patent office. So after the search, assuming that comes back clear, what we do is we prepare a patent application. That's where we're sort of disclosing the invention to the patent office and asking for the monopoly. And the patent application has a number of different parts, but primarily it's a written description of the invention, drawings where it's sort of available, and then the claims of the patent. And that's what defines the legal monopoly that you get. So the language of the claims, how you've claimed your invention, is sort of sometimes referred to as a fence. So you're describing a fence around your invention, and other people infringe by doing something that falls within that language of the claims. So that's the most kind of technical part of patents, but really important to focus on, because patents can describe a whole bunch of things, but what they claim may not be exactly what's described or shown in the drawings. It might just be a small subset of that. So if you're looking out there as a new business saying, am I going to infringe on anyone else's patents doing what I plan on doing? It's the claims you need to focus on, because that's what other people have a monopoly in. So patent applications, as I sort of alluded to, are subject to examination. So the process generally takes between 2 to 4 years for filing through to grant. So long process, and that's going to be a bit of a theme with intellectual property applications. But patents are by far the longest, and that generally relates to the number of steps you might go through in that process. There's sort of an optional international phase that you can go into, which delays things by 18 months. There's a 1-year provisional period you can make use of, which most people do. So if you have questions about that, I can get into it, but I'm going to kind of gloss over those details and just say it's about 2 to 4 years. It gets examined by a patent examiner, and that's typically where the examiner will say, I think it's too close to something else that exists, and I don't want to give you the patent. And then somebody like me will argue back with the examiner to say, actually, it's different from that thing, and we should get the patent. And so there's a back and forth, and then hopefully at the end of that, your patent is issued, and you get your 20 years of exclusive rights to that invention. So that's kind of patents in a nutshell. The next one is trademarks. And so trademarks basically protect brands. So you think of things like Google or the Nike swoosh or different sort of brand imagery. Those would be protected classically by trademark registrations. So trademarks can be either registered or unregistered. So a little different from patents in that sense. Registration has a number of advantages though, so it's definitely preferred to an unregistered trademark, but you can still enforce rights in an unregistered trademark. It's just more difficult. So what does infringement mean in the context of trademarks? What is that exclusive right for trademarks? So it's a little different than patents. Trademarks don't prevent anyone from sort of making or selling a particular product, what they prevent people from doing is selling products in association with your trademark. So they can't sell the same kinds of things you're selling with that brand or a brand that's confusingly similar to it. But they can still sell shoes without infringing Nike's trademark as long as you're using a different trademark. So the protection is a little different. It protects the brand, not the goods themselves. Another distinction between patents and trademarks that's important is that trademarks are not term limited. So you can have a trademark forever in theory, as long as you keep using the trademark. So there's no 20-year limit or anything like that. They can last as long as you want them to last. So basically, the idea behind trademarks is that trademarks are a source identifier for the public. And in that sense, they've got a bit of a consumer protection role. It's supposed to be a quick reference guide for consumers to be able to know where they're buying their product from. So you look at the brand and you say, okay, well, I know that's a Nike shoe, or I know that's a President's Choice food product. So I kind of have a sense what that means because I'm familiar with the brand. And so in that sense, there's kind of a reputation and a goodwill component to trademarks because people come to recognize that a particular brand is associated with a particular quality standard, and so they look for that brand over other brands. And so what trademarks have kind of come to be used as now are kind of commodities in the sense that you're trading on that goodwill and reputation. So people license their brands to other companies to use. That's a very common thing now. So it's gotten away a little bit from the source identification concept and is more of this commodity and goodwill and reputation concept now. So it's the sort of goodwill with consumers that the brand represents that the trademark is intended to protect. Like other kinds of IP, it's protected separately in each country. So sometimes what happens is one person owns a brand in Canada and another person owns that same brand in the United States. And this, frequently results in litigation, but it's possible. Not a great idea, but it can happen. So it's important when you're starting out that you sort of think about your potential markets in addition to just your current markets, because someone may run off and register your trademark in other countries you may want to expand to down the road. And that can be an obstacle for you when you're looking to move into those countries. So typically what people will look at is, because we're in Canada, we'll be looking at Canadian and United States trademarks because we live here and US is the major market. That's typically what most people go for. But we also register trademarks for people in Europe, Australia, Russia, Brazil, Mexico. So you can kind of go anywhere, but you have to look at sort of the cost benefit of doing that, because there's no sense in registering in a country you'll never sell in. So similar to patents, there's an application process. We start off with a search. The search is designed to do something similar, but it's to look for trademarks that are too close to yours and are likely to be an obstacle to register your trademark. After that, we file an application, goes through an examination process similar to patents, and ultimately is registered. Typically, that's about a 2-year process these days. The answer used to be sort of 14 to 16 months, but trademarks offices have been really inundated and also backed up with COVID. So it's kind of 2 years plus now. But they're working on it. So one other thing to note with trademarks is that they are registered in association with particular goods and services. So when you're applying for your mark, you list the goods you're selling. So let's say cupcakes. So if you're selling cupcakes in association with the trademark Google, somebody else may still be able to register the trademark Google in association with internet search engines without infringing your cupcake Google registration, because the marks are the goods are so different, people aren't likely to confuse the search engine company with the cupcake company. So that's a bit of a unique feature of trademarks, because you can kind of use someone else's mark, so to speak. But if you're in a sufficiently different sector of the market, that's not considered to be a problem. So that's something that catches people out sometimes, particularly when they want to expand towards each other's markets. You can end up with problems there, but that's the way it is. So the next one is copyright. And copyright is probably the one that's the most universally applicable to every business. Although every business will also have a brand. Everybody pretty much has a website these days, and everybody pretty much is showing photographs or images of their products on their website. So those photographs will be protected by copyright, and the copyright will be owned by someone, and you want that someone to be you. So how do you go about doing that? What does copyright look like, and how do you protect it? So copyright, again, is a little different from other kinds of intellectual property. It actually is automatic. So there's no application or registration requirement for copyright, although it's possible. It's not necessary. So copyright arises upon creation, and it protects artistic and other sort of works of authorship. And the idea basically is that upon creation, the author is the first owner of the copyright, unless there's a written agreement that says otherwise. Now that basic premise shifts in an employment context. So if the employee creates something in the context of their employment, then the employer is deemed to be the first owner of the copyright in the things they create. So a staff photographer, for example, taking photographs as part of their job, the employer would own copyright in those photographs. Same thing with staff writers or other creative staff, but that doesn't apply to independent contractors. And that's something that catches people out all the time. So with independent contractors, it's essential to have copyright terms set out in the independent contractor agreement. And that most often comes up in the context of web developers or other sort of IT staff, because generally speaking, those people will be contractors, whereas marketing people are more likely to be employees or partners in the company. So it's important, particularly for independent contractors, to have in their agreement copyright terms. But for employees, it's also good practice, just because you don't want to rely on that deeming provision in the Copyright Act. And with copyright problems, they are generally particularly difficult to resolve, because there's a sort of a sense of ownership and authorship that comes with copyright that is a little bit unique and different from other kinds of intellectual property, and doesn't always lend itself to perfectly rational dispute resolution. So it's much better to avoid those problems by having clear agreements up front than it is to try and sort them out later down the road. So there are a number of other types of intellectual property, and I'll kind of skip over them. They're much less frequently used, but there's also registered design protection. Confidential information is the big one I'll talk a little bit about. But then there's a whole bunch of other ones that basically everyone forgets about, like integrated circuit topographies, plant breeders' rights, and a few other things that are very niche and basically don't apply to most businesses. So the one I will mention, though, is confidential information and trade secrets. It's kind of self-explanatory in the name what that covers, right? It's information that's confidential. But how you protect it is different from other types of IP. There's no registration available for confidential information, and it can only be protected in two ways. One, by controlling access, basically keeping it a secret, and second, by contract, usually an NDA, non-disclosure agreement. And that's basically it. There are some sort of common law protections where it's implied that those things will be confidential, but you really don't want to rely on that. You want to have a written contract and protect confidential information that way. And confidential information can be highly valuable. Examples I typically use are the Coca-Cola recipe, which is probably more legend than fact, but you know, that's a piece of confidential information that's highly valuable. You know, the things that are more everyday confidential information would be customer lists, supplier pricing, things like that. And that applies to most businesses. So most businesses will have some confidential information. And so just being aware of that and taking some steps to protect it can help you down the road in the context of a purchase transaction or any other sort of merger or partnership. If you're able to sort of point and catalog your confidential information, it becomes an asset for the business rather than being sort of something you kind of know you have but can't really point a finger at. So I do want to talk a little bit about enforcement and sort of other reasons you might sort of work with a lawyer other than what we talked about, sort of applying for IP. Basically, the times you may want to engage a lawyer or patent trademark agent to help you with an IP question would be, number one, applying to secure IP. Two would be a sort of licensing or purchase or sale transaction of IP. And then three would be enforcement. Either someone's enforcing their IP against you, alleging that you're infringing their IP, or the opposite, someone's infringing your IP and you're trying to stop them. And that sort of latter category of enforcement, I've noticed really exploding in the context of the pandemic because so many businesses are now online and so many small businesses are starting up online that brand and copyright infringement in these small businesses has become a major problem. And it's just as much a problem for the big brands as it is for the startup brands. So it's kind of important to think about these things early on because of the lead time in registering things like trademarks. You want to have that trademark registration ready when you need to enforce it, not start thinking about registration when the need for enforcement arises, because it's going to be about 2 years before you get that registration. I want to leave some time for questions, so I'll sort of gloss over enforcement, but basically IP rights are private property rights, and you enforce them like any other civil claim. Bring a lawsuit and take the person to court. Typically, it's very expensive, particularly for patent litigation. So I wouldn't recommend anybody makes that a part of their business plan. But if you need to, that's how you do it. And typically, you would kind of do it in the context of an existential threat to your business. Otherwise, it's kind of not worth it because it's sort of $100,000 or more to go all the way through to trial on one of these cases. So it's almost never worth it unless there's hundreds of thousands of dollars in damages you might be collecting. But what can be quite effective is writing cease and desist letters against small infringers because they'll take that to their lawyer and their lawyer will tell them what I just told you, that it's very expensive and you don't want to have one of these problems. And then it becomes a bit of a game of chicken. So that's kind of the enforcement in a nutshell. Aside from enforcement, licensing is a big thing. Licenses are basically permissions to use your IP. It's a contract, and you can put whatever kind of terms you want on it. Royalties are very common. Geographic restrictions are very common. So you could license someone for Northeast United States territory, Western Canada territory. So all those things are options you can bake into a license agreement. And then sale of IP as part of a business is a big thing that I do. Typically don't do a lot of sort of business sale transactional work, but the corporate lawyers in our firm will bring me in if there's a significant IP component of the business, and I'll sort of help with that. So it can be very useful to be organized about your IP if you're contemplating potentially selling your business in a few years, because the more organized you are about it, the more attractive those assets are going to look, because you've sort of tracked them the whole way, and you're able to give a better explanation of what and where those assets are. So important to think about those things early, and not just when the need arises. So yeah, other than that, I think happy to answer any questions. And I understand you've been thinking about IP for a while now, so you probably have a few questions.
Thank you, Jamie. Yeah, the floor is yours, guys. You can see their hands up, Jamie.
I can. I'm sort of getting a flood of them, so I can go from top left on my screen, or David, if you've got a more organized way of handling questions.
No, you go right ahead.
Okay. Well, Tracy's on the top left of my screen, so Tracy, you go ahead.
So I have a photography, videography, and live broadcasting company, and I have like way too many questions, I think, for you to answer all at the same time. But I was wondering, I have like a list. So I was wondering about like contract workers and like how, like, so we just put in the terms of copyright. So like, because it looks like we'll be hiring on staff, like permanent staff in the future, but not quite yet. And so we do need some contract workers. And with video and photography, that's all there. And then with regards to like live broadcasting events online, I'm just wondering, like, do you have any input on how to go about that? I guess those are my main two questions.
Sure. So in terms of the contractors, because they're contractors and they're doing photography and videography, the copyright is kind of a key component of what they're delivering for you. And because they're not employees, any assignment of ownership of that copyright has to be in a written agreement. Otherwise, they retain ownership. So it's important in whatever agreements you have in place with them to include assignment of copyright in whatever it is they're providing for you. So if it's photographs, you want them to assign that copyright in those photographs to you as part of the delivery that they're, however they're delivering the photographs. So that can be done with, standard assignment language. Hereby assigns all right, title, and interest in and to the copyright subsisting in blah, 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 blah. If you didn't quite catch that, it's probably available online, or you can call somebody like me. In terms of how to go about the broadcasting, if you're broadcasting things that you own the copyright in, then you're sort of not worrying so much about copyright infringement issues. In terms of sort of logistics, it's not really my area, but you can sort of license someone to do a broadcast. So if you're sort of broadcasting on some other platform that isn't sort of a self-serve thing like YouTube or one of the other streaming platforms, then you would be working with someone to do the broadcast. And so there would be an agreement in there that would touch on copyright licensing and retaining ownership in those rights for you and what rights you're giving them. So you would want to, broadcasting is a pretty specific area. So you would want to kind of make sure you're covering those things off, unless it's just a YouTube thing, because then it's kind of their terms are there. And if you want to use it, then you're using their terms. There's not really a negotiation. So, you kind of take it or leave it. You still want to have an idea what those are, but it's kind of more just reading it for your own information, not so much that there's anything to be done about it. Does that kind of answer the question?
Yeah, thank you.
Okay. Evity, you're up next on top left to right on my screen.
Awesome. So yeah, she's right. There's a lot of questions, but I'll try and narrow it down. So from what I've understood, because my business is actually a movement, a social justice movement, and my business would just be like the legs of the movement. And so I want to know, can I patent the movement? Like, for example, there's like the Pan-African movement that is similar to mine, but different because of our objectives. I don't know if that's patent, as well as like the Black Lives Matter movement type thing. I don't know if those are patent or if those are trademarked or anything. But like, because my movement has an actual process of how we are trying to reach our goals, like it's actually goal driven. So we have a process. So I'm like, would I need to patent that, as well as so like trademark We Black, because that's the name of the We Black network, but like under We Black is the movement, but it's not going to be introduced until all of our different sections are out there. And in the search that I've done, I do see people that are doing like We Black fashion show, We Black, different things like that. So I'm like, as soon as I trademark, can everyone that's doing anything that is associated with that name, can I send them a cease and desist letter? And last thing is, until I have that done, what can I actually do? Because if it takes like 2-4 years, and it's something that I know that once this is out there, I know a lot, like it might be intriguing for people to kind of start doing the same thing as well as people we're working for, then how do I operate now without it infringing on the application process?
Sure. So I'm going to answer that third question first, because it's kind of the easiest one to answer. So with the delay and everything in the IP application processes, most people typically don't wait until the end of the process to start their business or whatever their commercialization of the trademark or patent looks like for them. The key time is the application filing. And so you generally, specifically for patents, but sometimes also for trademarks, don't want to come out ahead of the filing of your application. But once you're filed, you've established a priority date is what it's called. So because most IP systems are based on a first to file system, if you establish a filing date, someone else comes along later with the same thing, trademark, patent, whatever. If their filing date is after yours, your application takes priority over theirs, and yours will succeed and theirs will fail. So that's basically the answer to number 3. You file and then you go. As far as number 1, the patentability of generally would be sort of business processes, is what that would fall into as a category, is a little bit tricky, and it varies country to country. So in the States, it's more open to patent business processes generally than Canada, but it's still a little murky. So generally what you're looking at doing is identifying a number of process steps that are unique to the way you're doing something. And the way they have to be unique is kind of in a functional sense. Sort of you're doing something that's different, or the way you're doing it results in something different. So, I mean, classically what these things would be, processes would be sort of manufacturing processes. That's where the origins of process patents comes from. So you kind of have to sort of pigeonhole things into that type of mentality, right? So step one is this, step two is this. And if there's something that's new about the way you're, conducting charitable work or driving awareness of certain, campaigns, then that may be something that could be a business method patent, business process patent. But it's very difficult to sort of say whether or not it would be patentable because it's a bit of a murky area. So sorry for the non-answer answer. In terms of number two, I think I still remember what the question was. You're asking about sort of what kind of protection you should be going for?
Right. Can if I trademark the name,
Sorry,
can
right.
it come back from everyone that's currently using it right now that
Right.
doesn't have it trademarked?
So the way that trademarks work, there is a filing priority between applications, but there's also a question of first use. So when you use a trademark, you get you begin to accrue unregistered trademark rights, and those can impact someone else that comes along later to try and register that trademark because you already have some rights. Now they're more limited, and it gets kind of complicated in terms of you may have rights in London, Ontario, but nothing in Alberta or BC. So there's a territoriality aspect to unregistered trademark rights. So it's a bit of a complicated question, but if a bunch of people are using the mark already, it may not be registrable because it's not distinct to you when you file. So that's a problem potentially, depending on how widespread the use of WeBlack is. But that's something you can kind of assess in the context of looking around at how many people are using it, what they're using it for, and how different that is from what you're planning on using it for. Because as I mentioned before, trademarks are kind of specific to goods and services. What concerned me about that though was the fashion lines, because presumably there would be t-shirts and things associated with the movement as well. And so that would be an area of overlap with a fashion brand. So that's potentially a concern.
Thank you.
No problem. Cecilia, you're up next on my screen.
So I have a small clothing brand, and I have a lot of unique designs that are really beneficial to my customers. So I'm wondering if I need to be trademarking or copywriting the actual drafting patterns that I'm using to make those clothes.
Okay. So with clothing and fashion goods generally, it's a bit of a challenge to protect those things with copyright, because copyright has a statutory limit of 50 copies of something. So once you've applied a design to 50 or more, is it 50 or more? I think it's 51 or more. Anyways, it doesn't really matter if you're running hundreds of t-shirts or something, but basically once it's a run of an item and not sort of a collector's or sort of unique limited edition thing, it's no longer protected by copyright. Now, images and things like that can still be protected by copyright, but the article itself, so the dress or the handbag, is no longer protectable by copyright. It shifts over to registered designs. So that's part of this kind of interplay between different types of IP. I didn't go into it as much, but there's kind of often overlap between different kinds of intellectual property, particularly sort of trademarks, copyright, designs. The same thing can be sort of protected in a number of ways. So one thing you might want to think about is designs, but I've talked about this with a number of clients before, and it usually ends up being cost prohibitive in the fashion context, because fashion turns over so quickly. So by the time you register this year's designs, it might last you a year or two, and then you don't need those registered designs anymore because you've turned it over and you've got new designs. So most often what fashion brands will use for protection is trademark protection. That's what Louis Vuitton and all of the other major brands rely on. And so that's kind of why every Louis Vuitton handbag has the Louis Vuitton plaque and logo on it, so that knockoffs can be identified and as trademark infringements. So that's where the sort of trademark becomes important for fashion brands. The difficulty is if you don't want to have a logo on your stuff, and then that's where it's just very difficult to protect. I don't know the name offhand, but there is a famous brand of women's shoes with a red sole. So there's no logo, but that red sole is a trademark. And so you can get into non-standard trademarks, and things like a red sole on a shoe can be a trademark. So you could think about something like that. It's more difficult and it's going to take longer to get it registered because you have to first build a brand identity in that unique element. But if you're able to do that, then you can protect that unique element separately from, a big round logo if that's not going to fit with your the sort of aesthetic of your brand.
Okay, thank you.
Okay, Brittany, you're up next on my screen.
Hi, so I run a double Reeds supply store. So like we sell music supplies to bassoon and oboe players. And we recently have been starting to like make some of our own products. And so one of them is like a new tool that has been like is an adaptation of something that is already on the market, but like free for anyone to reproduce. And so we haven't released it yet, but we're just kind of wondering like if we should be looking at patenting it because it is something that can be easily like remade, but then also what might be the cost for that, because all of our competitors are actually mostly in like the US and Europe. There's not many in Canada, so that would probably be covering a larger area geographically. So I was just wondering what your thoughts on that was.
Sure. So, I mean, new tools are kind of classically patentable subject matter. It'd be a new device of some kind. In terms of the cost, patent cost does vary sort of based on the number of countries. Each country charges its own set of government fees for filing the application, examining it, all those different things. So the way that we do our costs, not everybody, but we do our costs for patent work based on a fixed fee, system. So our fees are basically the same for preparing a patent application, whether you file it in one country or 50 countries. But the government fees start to add up if you're looking at, a dozen different countries, because they're typically between sort of, 600-700 and maybe 3,000-4,000 for different countries on the high end. And then, so it does get expensive, but if you're looking at sort of a Canada, US, and maybe Europe is one of the more expensive jurisdictions. That's why I sort of hesitate about that. But the cost for Canada, US, I don't know if you can hear my dog in the background. Sorry about that. The cost is kind of staged out, right? So I mentioned it's a 2 to 4 year process. So that helps a little bit. The cost for the first year is kind of like $5,000 to $6,000, and then at the 1 year mark, there's about another sort of 9 to 12. If you're doing Canada, US, Europe, it might be more like 13, 14,000 on the high end. And that's the bulk of the cost. But then there's the examination, which varies. So I've had applications go through without any objections from the patent office. It's very unusual. Usually there's at least one back and forth, but sometimes they do go right through. In that case, there's no cost to the examination. It's just done. Pay the registration fees and get your patent. But usually there's a back and forth, and typically each time we prepare a response to the patent office, it's sort of $800 to $1,100 for that response. So
Okay,
that's
thank
kind
you
of
so much.
that's the rough cost. I have a cost sheet I can send you if you want to send me an email after this, and it's got a better breakdown than I just gave.
Okay, I will. Thank you.
No problem. Steve and Janin, you're up next.
Okay. I have a question about developing your brand. So we haven't opened our business yet. We have a name for the business, but we don't have like a logo or any sort of like branding done yet. So what do you think is the process? And like, if we want to work with, say, a graphic designer or like a marketing firm or someone to help us with that, like, whose responsibility is it to ensure that what's created is not infringing on someone else? And like, is there a way like we can protect ourselves from, you know, a couple of years down the line, like someone coming to us and saying, oh, like you ripped off our logo kind of thing? And then sort of part of that too is like, should we be doing the trademarking and things of the name and like get all that firmed up before we even try to make a logo and continue with that name?
Sure. So basically the decision on what your brand is going to be is kind of step one. If your brand is primarily a word or a name, then that's probably what you want to try and register. I didn't get into this before, but I sort of alluded to it with this earlier with Cecilia's question when I said that there are sort of non-standard marks. The quotes standard marks are either words or designs. So you can have just words, and then that registration, the scope of that registration actually lets you use it with any design you want. As long as the word is there, that's within the scope of that registration. So if your brand is primarily a word or words, then a word mark is the best form of protection for you. And that's what you should go for. And if you want to put a logo together to go with that later, you can do that. And as long as it's still using the words, you're kind of covered. You can cover both, but for a startup, I don't recommend that because you're just loading up on trademark costs. And why? The other part of your question is a really important one, because whose job it is to do the trademark clearance, gets messed up even at the high levels sometimes. I was involved in some litigation a few years ago, and one part that we weren't involved in was what happened between our client and their design and and marketing company after the litigation, because they were not happy having landed in that litigation after a rebrand. So it's important to make sure you know, are they doing the clearance work or are you taking on that responsibility yourself? Because if both people think the other person's doing the clearance work and it doesn't get done, you can have a problem. And it's not a problem you want to have, because trademark problems usually mean one of the parties is rebranding. So you don't want to be in that situation.
Okay, thanks.
Okay, no problem. Abigail, you're up next.
So my question is surrounding products liability because I'm developing a hair care product line. And so I was talking to my financial advisor, and he said, like, usually it's done with bigger companies where they register almost like a numbered company for each individual product, so that if there's ever an issue, the whole company doesn't get sued, just that individual product line gets sued under that numbered company. Would you advise that for somebody who's starting out but has aspirations to have multiple product lines?
Short answer is no, I think, because you don't need the multiple corporations until you have product liability that you want to separate, right? The whole idea behind doing that kind of a corporate organization is to manage liability risk throughout the organization. So what you're doing by siloing those products in different corporations is making sure that the whole ship doesn't go down with, one problem. But if you only have one product line right now, there's nothing to separate. So I think what you can do is you can take a modular approach to it. So when you add a new product line, you can do a new corporation. You can have one brand and license that brand to all of the different operating companies. And that's something that's done very frequently, as you'll have a holding company and then operating company or companies. But I wouldn't rush to register a whole bunch of companies right now, because there's a cost to registering a number of companies, and then there's upkeep. So you need to file taxes and annual returns for companies. So that means accountants, that means more fees. So you kind of want to be as lean as possible when you're starting up. Definitely a corporation is a good idea if there's any concern with product liability, because you don't want your personal assets to be at risk. You want to be able to, walk away from the company and let it go down in flames, but not lose your house, right? But you don't need more than one corporation if you're not looking to separate that liability from different things. So I wouldn't recommend a whole bunch of corporations, but I would recommend one.
Okay, so basically not until my volume is at that point. Like, I'm planning on launching maybe 3 to 4 individual products at the beginning, and then gradually adding additional lines. So then doing the individual corporation when I add each line, when I'm doing the volume that requires that.
Yeah, it's a little specific. I don't know that I can I would need more information, I think. But one thing you might want to think about is different jurisdictions. So if you're selling your product online into Canada, the United States, Europe, etc., you might want to have different companies in the States to handle US liability, in Canada handle Canadian liability, so that you're not exposed all over the world. But again, that's kind of expensive. So it's always a cost benefit question when you're looking at doing things like, corporate structures for risk management reasons. You got to say.
Yeah, I was a little worried about that because I do plan to sell online, but I wasn't sure exactly how to go about that. So I will speak to somebody like yourself and get more information. Thank you so much.
No problem. I'd be happy to chat. The other thing I'll mention is insurance is also an important part of that. So you want to have a problem that's within your insurance limits, so that you don't have to walk away from a corporation and let it go bankrupt. But you also want to have that option in case a $50 million claim comes and you just don't have enough insurance. So that's kind of, in a nutshell, why you take those steps. But the best situation is to be able to rely on an insurance policy to cover it, and not have to worry about restructuring after some kind of disaster scenario.
Okay, thank you. I appreciate the information.
My pleasure. So I don't see any more questions, and we're at about 4 o'clock. I think we already had somebody have to drop out, but so I'm happy to, if you've got any other questions, feel free to email me or anything like that. I think you can find me on the website, and I'd be happy to chat if you have any IP issues, or connect you up with somebody else if it's not in my area.
Thank you so much, Jamie. I can't express how much we really appreciate this. I think this is the most questions we've had out of any guest speaker so far, and I was very surprised with how how many of you or just have all these questions in your head that we didn't know about ahead of time? And so Jamie, thank you for bringing your expertise to the table here and sharing all this information and being available for everybody. I really appreciate that. I do know one of our individuals had to drop out just before you showed up. And she's a baker, and she did have a question about recipe stuff. So I'll instruct her to shoot you an email. She was just curious about protecting some recipes that she's created. So thank you again for all your time. We really appreciate you joining us. And before you go, everybody give Jamie a nice farewell wave. Thanks everybody, and thank you, Jamie.
Well, thanks. My pleasure. Nice to see you all, and good luck with your businesses.
Thank you.
All right, take care.
All right, guys. Well, that was a long one again today, but I think you guys all had a lot of questions. Hopefully that cleared up some things for you. Obviously, there's probably more questions you'll have, so don't be afraid to get in touch with Jamie, or if you've got a local lawyer, family lawyer, someone else that you trust as well. Make sure you're starting to reach out. You should have general protection. You should have a general business lawyer that you're in contact with at some point in time. So if this is kind of your first introduction to that, you should be thinking about, okay, like, who do I want to get in touch with? On July 6th, we will be bringing another general business lawyer in to discuss company formation, company structure. So more about incorporation, legal structure, things like that. So don't worry, we are bringing another lawyer back. So there'll be more questions directly related to that. I did want to just mention, I put some other links for you guys to around just regulations. Some of the things that come up usually when we talk about IP is, oh, are there any other things I should be worried about? So I put some links that's just like a business regulations guide, a permits and licenses search tool through BizPal. And then I put the link for contacting Service London Business up on FOL so that you guys can have access to that. So if you're thinking, if this is exposed to other regulations or legal components that you're asking questions about, between the 4 links that are on there, you should be able to find some helpful resources. It'll be up there with the deal prep links as well. So with that, I say farewell to everybody. You have a great rest of your day, and we will see you back tomorrow for the beginning of marketing activities and tactics that's going to go for the next couple of weeks. All righty. And if you need to ask a question, feel free to stick around.
The first time I have no question.